This courtroom drama takes a shocking turn when a landlord tries to evict a tenant who allegedly owes more than $12,000 in unpaid rent, but what unfolds is anything but ordinary. Instead of a simple legal dispute, the hearing quickly spirals into chaos as the tenant delivers a string of unusual explanations and emotional appeals in an attempt to avoid eviction. From claims of severe illness and long-term health complications to the extraordinary assertion that exposure to Wi-Fi and electronic signals could physically harm her, the courtroom is left stunned. The judge listens carefully but remains focused on the legal facts, repeatedly steering the conversation back to the core issue: unpaid rent and possession of the property. Meanwhile, the tenant insists she has nowhere to go, no support system, and no realistic way to relocate due to her medical condition, creating a tense emotional clash between personal hardship and legal responsibility. As the exchange continues, frustration builds on both sides. The landlord wants resolution. The tenant wants more time. And the judge must balance compassion with the rule of law. Just when it seems the situation couldn't get more complicated, the debate over whether the tenant can even appear in person adds another unexpected twist, forcing the court to make a last-minute procedural decision. What happens next could determine whether the tenant keeps a roof over her head, or faces immediate eviction. This is one courtroom confrontation you won't believe until you see it.
October 4th of this year, I gave the defendant the proper 30-day notice demanding possession of my property because of non-payment of rent.
Well, okay, let me stop you there.
Okay.
A 30-day can't be the subject of a non-payment of rent action.
Okay. So.
All right. Do you want her to move, or are you just terminating her tenancy? I mean, are you terminating her tenancy and want her to move, or do you want her to pay you?
I want her to move, and I want to also have a money judgment. So I can't do that?
Yes, you can do that.
Okay, that's what I want.
Okay. Go ahead.
Yeah, and I'm seeking a money judgment from the court for all back that she owes me as of December 1st, 2023, which is $11,995 plus court costs $215 and service fee of $68.
So how much is your
So the total
claim?
money judgment requested from the court is $12,278.
All right, Ms. Gerler, what do you have to say to that?
Your Honor, when I first moved in, it was to be a temporary arrangement. I had another place lined up that did not end up being represented appropriately. It was to be vacated and renovated. Didn't happen. I have attempted along the way to give Ms. Peel, the plaintiff, money. I became extremely ill with COVID, which I have long COVID, along with 2 other disabilities. When I became behind in rent because of illness and sought help from local agencies, the plaintiff was offered money from Faith in Action, and she declined those monies. And there were other monies from other agencies that would have been available that would have satisfied my arrearages at that time of $2,985. Declining those monies led me to believe that she simply wanted me to move out. So I tried to start packing possessions, became ill with COVID again. I have, in the court documents, outlined to you the many times since then that I have been afflicted with every COVID variant. I already have a serious extreme condition of electrohypersensitivity that I cannot easily find a place to live. I cannot live in group settings, be exposed to Wi-Fi, wireless meters, be near cell towers. I need a rural environment. No longer have a vehicle. I cannot use cell phones, smartphones, computers due to my electrohypersensitivity, and I thank the court for granting this Zoom appointment at the last minute, since I was not supplied the forms necessary in the personal and mailing service I received, and was actually waiting because in our December 1st hearing with Judge Barr, he informed the plaintiff that she had filed incorrect paperwork and needed to refile. So I have been waiting for that paperwork to come, which I don't know if something changed and was not necessary. But
What incorrect paperwork? I don't have a notice to that.
Well, and that's whatever happened, Your Honor. That's what I heard in court, and I'm not privy to what happened thereafter. I am chronically ill, Your Honor. When I get well,
ma'am, hold on. Yes, ma'am.
I spoke with my attorney counsel yesterday, and she said my paperwork was fine. I think it was just not clear to Judge Barr what I wanted because I didn't know how to present my case. So,
well,
but
yeah, I actually see what Judge Barr is saying right now. Well, you filed 2 different notices. That's why. I got it. It's fine. I think. Hold on. That's not that one. Right. You filed 2 different ones, but you got, it appears to me, the correct paperwork. All right.
Your Honor, just to respond, that's what I heard from the judge. And my legal
but
counsel,
this is another judge saying that that's wrong. It's correct.
And that's fine. I have no problem, but I was waiting on that paperwork. I know that the plaintiff is someone who tries to do things appropriately, but what did not happen appropriately with this home that has been a long time rental is that there is no certificate of compliance on file with the township. And
so when are you going to move then?
Your Honor, I have had to deal with all the demands of the court, so I cannot explore that yet because I was required to apply for SER with the DHS, which was declined. I have contacted every agency available to me thus far.
Ma'am, do you understand she doesn't want you to pay rent and stay? She wants you to leave.
I understand that, sir, but to comply with the court and the paperwork required for this hearing, DHS, that's where I have put my first attentions. I have been packing and moving things out of the house, which they have witnessed, but because of my extreme sensitivities, it is not easy for me to find a place where I can live safely. I have just recovered from my last bout with COVID, which has severely impacted me for the last 4 years and created these issues. And I have also...
Ma'am, I understand all of that. The question becomes, when can you move?
That is a question mark to you and me both, Your Honor. I do not know. I have nowhere to go. I am solo in this world. I have no vehicle. My car broke down June of 2022. And my situation is not a good one because of chronic illness. Reliable and sometimes 12 hours in the bed.
Okay, ma'am, I can appreciate all of that. But you also have to understand that the landlord is entitled to her premises back.
I understand that they request their premise. Have an appointment with Hawk on Monday. To what degree that will help, I do not know at this point. I have been unable to find assistance from anybody because they say I am not sustainable, because I am now forced to live only on my Social Security income. The
Okay,
house line.
all right. Okay, ma'am. Here's what I'm gonna do, because this has gotta. I understand the difficulties that you're telling. I also understand that the landlord needs to resolve that. So I'm going to set this for a trial. You've raised some issues in your answer, but I'm going to set it for now. Yes, ma'am.
When I talked to my attorney, she said that there is no requirement for the compliance regulations in Webster Township where I live. And she's an attorney from Dexter. So,
Oh, they know
And that
more.
was-
They know more than us here, us other country folk from Pittsfield, or what?
I guess. I don't know. That's what she said. Is that correct?
What?
That's what she said.
I don't know. I guess she's from Dexter, so she knows more than us.
Township does
We're
not
just
issue.
little country judges up here. Ma'am.
I actually called the zoning person too. She
Okay.
said-
And she said, yeah, probably
She said-
she agreed.
I'm having difficulty hearing, Your Honor. Could that be repeated?
No. Okay. She went to Webster Township. The issue regarding this certificate of occupancy, it really isn't an issue because they don't require it for rental properties in Webster Township. That's the long and short of it.
I would like to know then why Legal Services of South Central Michigan gave me this form and checked
Okay,
it out. They
ma'am,
must
I
have
don't
obviously
know.
just-
You guys keep talking about lawyers. I've not met them. I don't know. All I know is this. You two are in front of me arguing a case. You have one position, plaintiff has another position. So here's what I'm going to do. I'm going to set this matter for non-jury trial. It will be in person.
Your Honor, that I hope you realize is not possible for me. I'm even being harmed waiting for 2.5 hours on my cell phone, which is on speaker remote
Ma'am,
from me.
then I don't know how I'm going to get you into court.
How is is it not possible for me to continue in this manner, sir? I have been before you to establish the severity of my condition. I become debilitated, incapacitated, ill. I lived in the basement of my prior home for 7 months because of radiation poisoning, and by necessity, where your court is located, there are many electronic communication requirements for police, fire, the cell tower, Wi-Fi for the buildings. I will literally fry and be unable to move. That's why I couldn't come. Not a fun scenario. And the landlords are well aware of my conditions. They had mitigated the house. They used Ethernet.
All right, ma'am. All right, look. Do you have any problem if I hold a trial and she appears by Zoom?
I guess not. I've been without income for a long time, and my preference is.
Okay, look, folks.
Yeah.
There are a lot of folks out there that are
Everyone
having
has
a hard
sad
time,
story.
and I get it.
Yeah.
Okay, I have to deal with it every Friday, so I don't know that I can help you with any of that right now.
Right.
I'm just trying to set a trial date. Do you
Sooner
have
the
any
better.
objection to her?
Tomorrow,
What?
tomorrow, the sooner the better.
I'm not coming in on Saturday. I'm this is not happening.
How about Monday?
No. What? We can do when? What time? 1 o'clock on Wednesday? Oh no, I can't do 1 o'clock. What time seriously can I do? Non-jury trial, December 20th, 2023,
At
9 a.m.
9 a.m. Okay. And,
You need to appear in person. Ma'am, you can appear via Zoom.
and right here?
Absolutely, that's where I'll be.
Okay.
And if I don't get this docket done, I'll be still sitting here from this one.
All right, thank you.
Thank you.
Okay, thank you, Your Honor, for the accommodation for my disabilities. I appreciate your sensitivity to the matter and your humor.
This courtroom hearing starts off like many eviction cases do, a landlord seeking possession of a property after months of unpaid rent. But within minutes, it becomes clear that the situation is anything but typical. The amount owed has climbed to more than $12,000, and the landlord is asking the court to finally move forward after what they describe as repeated delays and unresolved payments. From their perspective, the case is simple. Rent wasn't paid, notices were given, and now they want their property back. But when the tenant begins to speak, the tone of the entire hearing shifts. She explains that her financial problems didn't come from irresponsibility, but from a series of health crises that changed her life. She claims she became severely ill with COVID-19 and continues to suffer long-term complications that limit her ability to function normally. She describes chronic symptoms, fatigue, and disabilities that she says prevent her from maintaining stable employment. As she talks, there's a mixture of frustration and desperation in her voice, as though she feels misunderstood and cornered by circumstances she never expected. Then the hearing takes an even more unusual turn. The tenant insists she cannot appear physically in the courtroom because of what she calls electro-hypersensitivity. She claims exposure to Wi-Fi signals, electronic devices, and cell towers could cause serious harm to her body. According to her, entering a courtroom environment filled with technology would make her physically ill, even to the point of shutting her down. The statement creates a moment of disbelief, and you can sense the judge carefully choosing words, trying to remain professional while also addressing a claim that falls far outside typical legal arguments. The judge redirects the conversation toward procedure, explaining that court appearances are normally required in person, especially for a trial. But the tenant continues to insist that appearing physically would endanger her health. She repeats that she has nowhere else to go, no vehicle, no support system, and no realistic way to relocate because of her medical limitations. She describes herself as completely alone in the world, trying to survive while dealing with chronic illness and financial hardship. At the same time, the landlord's position remains firm. They emphasize the unpaid rent, the missed deadlines, and the ongoing occupancy of the property without compensation. From their standpoint, sympathy cannot replace legal obligation. Property ownership comes with rights, and they argue those rights have already been delayed long enough. You can feel the contrast between the emotional appeals from the tenant and the practical concerns from the landlord, two realities colliding inside one courtroom. The judge attempts to keep the discussion grounded in law rather than emotion. Questions are asked about documentation, previous filings, and whether assistance programs were offered or refused. The tenant claims that financial aid may have been available but suggests the landlord declined certain opportunities that could have resolved the debt. The landlord disputes this, creating another layer of conflict where facts themselves seem contested. As the conversation continues, the judge announces that the matter will move forward to a non-jury trial. That decision alone raises the stakes. A trial means evidence, testimony, and a final ruling that could determine whether the tenant remains in the home or faces eviction. For the landlord, it represents progress toward resolution. For the tenant, it represents the possibility of losing the only housing she says she has. But even that decision isn't the end of the procedural debate. The issue of how the tenant will attend the trial becomes another point of contention. She repeats that appearing in person is impossible due to her claimed medical sensitivity. The judge initially stresses the importance of physical presence in court proceedings, but after continued insistence and discussion, a compromise emerges. The tenant is ultimately allowed to appear remotely through video conferencing for the trial. That moment reflects something larger about the legal system, the constant balancing act between strict rules and human circumstances. Courts operate on procedures, deadlines, and evidence, yet they also encounter individuals facing real hardships, illnesses, and personal crises. Sometimes those worlds align neatly, and sometimes they clash in ways that create tension, frustration, and controversy. Throughout the hearing, emotions remain just beneath the surface. The landlord appears focused and determined, wanting closure after months of uncertainty. The tenant sounds overwhelmed and defensive, trying to explain why she believes her situation deserves understanding and more time. Meanwhile, the judge maintains a measured tone, working to ensure the process continues fairly despite the unusual claims and repeated interruptions. What makes this case so compelling isn't just the legal dispute itself, but the human conflict at its center. Housing is deeply personal. For landlords, property represents investment, responsibility, and financial stability. For tenants, housing represents security, survival, and dignity. When those interests collide, especially under financial strain, the courtroom becomes the arena where those competing needs are forced into legal definitions. There's also a broader question raised by situations like this: how systems handle individuals who claim medical or personal limitations that complicate legal processes. Courts must rely on evidence and procedure, yet they also encounter claims that fall into gray areas, conditions that may be difficult to verify or accommodate. Deciding how much flexibility to allow without undermining fairness becomes part of the challenge. As the hearing moves forward, you can sense that both sides feel wronged in different ways. The landlord believes they've been patient long enough and deserve enforcement of the lease agreement. The tenant believes circumstances beyond her control led to the situation and fears losing everything. The judge stands between those perspectives, tasked with applying the law while managing a situation filled with emotion and complexity. By the end of the session, one thing is clear: the conflict is far from over. A trial is coming, and the final outcome will depend on evidence, testimony, and legal standards rather than personal narratives alone. But regardless of what the final ruling will be, this hearing already highlights how unpredictable courtroom moments can become when personal hardship, legal rights, and unusual claims intersect. Cases like this remind us that behind every legal dispute are real people with competing realities, and sometimes the truth lies somewhere between sympathy and responsibility. The courtroom doesn't just decide outcomes, it exposes tensions that exist in society itself, from housing insecurity to financial pressure to the limits of accommodation within structured systems. And as the story continues toward trial, the biggest question remains unresolved. Will the law ultimately favor the property owner's right to reclaim possession, or will circumstances lead to more time for the tenant struggling to stay housed? Whatever happens next, this is one courtroom battle that has already captured attention for all the unexpected reasons.